Santiago Esparza Jr. Sir, you are here pursuant to a warrant for your arrest for the felony offense of tampering with evidence, namely a human corpse. The fact that it's a warrant means that probable cause has already been found in your case. Your case is assigned to the 351st District Court. The judge in that court is George Powell. Are you requesting a court-appointed lawyer to represent you in this case?
As of right now, yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you consent to allow Ms. Gonzalez to represent you at this bond hearing?
Yes, ma'am.
Mr. Sanchez, does the state have a position with regard to bond?
Yes, Your Honor. The state would ask that he be held at no bond. He is a true habitual, and we will be filing a motion to hold him.
I only see one pen trip.
I have a conviction out of Parker County in 2014 out of the 415th District Court for the felony offense of possessing a prohibited item in a correctional facility. And he also has a conviction for injury to a child out of this county from 2011.
Okay, I did not see the out-of-county conviction, which is a third-degree felony. Okay,
Correct.
thank you.
Yes, ma'am.
Ms. Gonzalez?
And can I ask a further question? Was he in custody? Was it one pen trip he was there on?
No, he has one from 2014 that he did 2 years TDC. And then he got 10 years deferred in 2009, and then he was sentenced to 4 years TDC in 2011.
If I'm correct, he picked up the offense while he was in custody in TDC?
I don't see how he could have picked up.
Just, can you clarify that for us?
I don't know either. I just show that I just have the dates for the
What's
conviction.
the offense?
Which
The prohibited item in a correctional facility.
So he was in prison at the time?
Yes, I see what she's saying. What she's saying is to hold somebody as a true habitual, they have to have been sentenced to TDC, done their sentence and gotten out, and committed another offense and done their sentence and gotten out, and now be charged with a third offense. And what Mr. Gonzalez is saying is he was still in TDC for the possession of a controlled substance in a correctional facility. So he didn't get out and commit another offense. And she's right about that.
Okay.
I didn't know if you wanted to change
Thank
his
you.
position and ask for a certain amount at this point. Proceed under the no bond.
Well, in light of that, Judge, then we would ask for an upward departure from the bond schedule. I'm not sure if you are aware of the facts of this case or not, Your Honor.
I am. I read the warrant before court, and I intended to ask Mr. Esparza. Did you want to hear the allegations in the warrant, Mr. Esparza?
No, ma'am, I already heard it now.
Okay, thank you. Go ahead, Mr. Sanchez. I did read the warrant.
I will say then, and as you're aware, and I'll just state for the record, that his co-defendant in this case indicated that there was evidence of injury to the child that she did not see on the child prior to Mr. Esparza possessing the child. I believe he was giving her a bath. And I would note that one of his prior TDC trips is for injury to a child. So I do have some concerns regarding community safety. And so we would ask for an upward departure in the bond schedule, and we would ask for a $100,000 bond in this case.
Ms. Gonzalez?
Judge, and if I may, the co-defendant in this case is the only evidence that's against him at this time, which case she started out by saying she was the one that gave the child a bath and then changed her story. So that is the only evidence at this time I believe the state's presenting. He has lived in the Houston area all his life. He has 3 children. A 5-year-old that he pays child support for in the amount of $500 a month. He also has a 9-year-old and an 11-year-old. He's lead maintenance, has a job. been there for the past year, making $2,600 a month. He does have several family members who would make sure he gets to court. I want to note, Judge, that he turned himself in yesterday to the detectives in this case. He has not, he's not a flight risk. He has, all his family is here. He's never been to Mexico. He doesn't even have a passport. Judge, we're asking that you set bond in the amount of $20,000, according to the PSA.
So,
He
he, go ahead.
I was going to say the injury to a child conviction is not his only conviction. His entire criminal history is full of assaultive and violent offenses involving both adults and children. With regard to the co-defendant's prior statement, I would just point out that while none of his prior assault family member convictions, as in plural, were committed against this co-defendant, the state would not be surprised if, she may or may not have not implicated him the first time around when she spoke to police out of fear of perhaps being retaliated against by him, given his history of domestic violence.
Okay, so, he has 3 prior felony convictions. One of those is the injury to a child, which he did 4 years TDC. He also has a state jail endangering a child conviction. In addition to that, he has an assault family violence conviction from 2015, 2 assault bodily injury convictions from 2009 and 2007. There is an extensive assaultive history, including one involving children. Based on that and the allegations in this particular case, Mr. Esparza, I am going to set your bond at $100,000. I'll refer any request for a lower bond or a personal bond to Judge Powell in the 351st. And that is for the safety of the community based on the violent history and the violent allegations in this case. Thank you, sir.